Let me paint you a picture. You are 34. You and your spouse both work in tech. Between two RSU packages, a 401k each, a brokerage account, and a house you stretch to buy, your household is worth more than your parents managed to accumulate. Now here's the uncomfortable part. If something happened to one of you tomorrow, a California court, not your spouse, could end up deciding who controls a large piece of it. And the reason is simple. For tech couples, the wealth showed up a lot faster than the paperwork did. Estate planning got filed in your head under things we will deal with when we are older, somewhere near shuffleboard and long-term care. Meanwhile, your account balances quietly crossed into seven figures and nobody updated a single document. So today I want to reframe this completely. I'm going to make the case that estate planning is not about being, but it's about owning things other people depend on. And I'm going to walk through the four pieces that actually matter: the will, the revocable trust, powers of attorney, and beneficiary designation, and why equity compensation makes all of this more urgent in your 30s, not less. One thing before we start. Drafting these documents is an attorney's job, and this video is not a substitute for one. What I'm giving you is how the pieces fit together so you walk into that conversation knowing what to ask for. Let's get it. Let's start with a will, because a will does less than most people think, and one thing that matters enormously. Here is what it does not do. It does not avoid court, and it does not control most of your biggest account, and we will come back to why. What it does do is name a guardian for your children and direct where your probate assets go. And for a couple in their 30s with young kids, that guardianship clause is the entire reason to do this. Because if both parents are gone and you have not named a guardian, a judge chooses who raises your children from a pool of relatives who may not be the people you would have in one of the most expensive places in the country to raise a kid. I want you to sit with that for a second. No amount of RSU wealth substitutes for that single decision being made on paper by you in advance. The will also catches everything that does not pass another: a brokerage account with no beneficiary, vested shares in your equity account, personal property. If it has no other route, it flows through the will. So the will is the floor. It is not the whole house, but you do not want to be without it. Now, the will has a catch, and this is where California specifically changes the map. When assets pass through a will, they pass through probate. And probate in California tends to be public, it tends to be slow, and it is priced against the size of your estate, not against the actual work. Think about what that means for a Bay Area household. Your estate is often inflated by two things at once: a house that is appreciated for years, and a concentrated position in a single company's stock. The bigger that number, the bigger the cost of dragging it through a public court process. So the common tool here is a revocable living trust. Your assets move into the trust while you are alive. You keep full control of them. Nothing changes, nothing about your day-to-day changes. But if you die, or if you become incapacitated, the person you named steps in without a court. And for a home that is appreciated the way Bay Area homes have, avoiding probate on that one asset is often the reason the trust pays for itself. One important thing: a trust only works if it is actually funded. That means the house and the relevant accounts get retitled in. That is precise legal work. It is what an estate attorney does, and it is not something to improvise. What you bring to that conversation is a clear list of what you own and how it is titled. The attorney builds the structure. Here's something most people miss entirely. They think estate planning is about death, but the documents that actually get used the most are about incapacity. And for a couple in their 30s, a temporary period where one of you cannot is the more likely event to plan for. There are two of them. A durable financial power of attorney names someone to manage money and sign documents if you cannot. And an advanced healthcare directive names someone to make medical decisions and records what you want. Without these, here's the trap. Your spouse assumes they automatically have this authority, and then they discover, at the worst possible moment, that a shared life still contains individually titled accounts, a solely owned equity account, and a retirement plan in one name that they have no legal standing to touch. And this is exactly where the disability angle meets the equity angle. Say you are the one whose name is on the option grant, and you are incapacitated during a vesting event or an exercise win. Someone needs the legal authority to act inside those deadlines, because equity plans do not pause for a medical emergency. The financial power of attorney is what lets your spouse act in time. Whether they can and what your plan allows is a question for your attorney and your plan. Whether they can and what your plan allows is a question for your attorney and your plan administrator. Do not assume it. Okay, this next one is the piece tech households get wrong most often, and it is the cheapest thing on this entire list. your 401k, your IRA, your life insurance, and often your equity and brokerage account. None of those pass by your will. They pass by beneficiary designation. Whoever is named on that form gets the asset, even if your will says something completely different. Let me give you the failure mode because it is almost always the same story. Someone names a parent as their 401k beneficiary at their very first job at 24. They marry at 31, they have a kid at 34, and they never go back and update the form. Fast forward through a few job changes, and there is a stack of old accounts still pointing at the wrong person. The will is immaculate. The money does not read the will. And equity deserves its own pass here. Ask your equity plan administrator what happens to your vested and unvested awards at death, because that answer lives in the plan document, and it varies from company to company. The same concentration in a single stock that makes diversification urgent makes the beneficiary designation on that account urgent too. So let's put it all together because this is the real argument of the whole video. Estate planning urgency tracks two things: how much you own and how concentrated and complex. And a tech job with equity compensation drives both of those up faster than almost any other career on the planet. Look at what you are actually holding: a concentrated position in a single volatile stock. Awards governed by a plan document you have probably never read. Unvested grants that may or may not survive your death. And account titling that has not kept pace with two fast-moving careers. That is not a simple estate. That is a complex one. It just happens to belong to people who feel way too young to have them. And that is the trap. The gap between your net worth and your paperwork is widest at the exact moment you feel least old enough to close it. That gap is the risk. So here's the bottom line. Estate planning is not a milestone of age. It is a consequence of owning things that other people don't own. If you have equity, a home, or a child, you already own that much. And the plan, drafted with an attorney, is simply the instruction set for the day you cannot deliver the instructions yourself. If you want to talk through your specific situation, the link to schedule a call is in the description. And if you haven't subscribed to Vested yet, my weekly newsletter for Bay Area tech professionals, the link for that is down there too. I'll see you next week.